Article 27.1 also states that patent rights shall be available and enjoyable without discrimination as to the place of invention, the field of technology, and whether the products are imported or locally produced. These three kinds of requirements and the criteria of discrimination pertaining to them are very unique in international patent scheme, in the sense that WTO member countries do not have the freedom to reject patents or to grant or not to grant the subject matter involving patents based on the criteria of place of invention, and also there can be no discrimination between field of technology. For example, WTO member countries cannot decide that they would exclude mechanical inventions or biotechnology inventions as a class per se. So exclusion of a class of inventions may be hit by the criteria of discrimination in the field of technology. Furthermore, you cannot also discriminate patents and grant of patents based on the condition whether the product has been imported or locally produced. So in this context, it is important to question whether lack of local working, as in the sense of local manufacturing, can be an important ground for compulsory license. However, this has not been settled. Brazil had unique provisions in its patent law which allowed it to grant a compulsory license for not locally working the invention, as in not locally manufacturing the invention. US took Brazil to the WTO dispute settlement. However, they mutually compromised, and Brazil agreed as part of the compromise that it would not use such provisions without consulting the United States prior to use of these mechanisms. This becomes crucial because India has similar provisions, and India has in the recent past invoked such a ground for the grant of a compulsory license involving Bayer's product Nexavar. We will discuss this in the next few slides. Article 27.2 allows member countries to exclude patents or exclude subject matter on the grounds of ordre public or morality. Now, how do you define ordre public or morality is not clear from the provision in itself. Member countries may also exclude patents apart from ordre public and morality on the ground that it may seriously prejudice plant, animal, or human life. However, such exclusion should not be based purely on the very nature of the invention itself, but must be based on the effects resulting from commercial exploitation of the invention. For example, cloning may be an area where patents may be denied, anyway, because anyway human cloning may be banned by virtue of an external regulation. In such cases where there is already an external regulation, probably that would be a fit case where patents may be denied for on the grounds of ordre public and morality, or that it causes serious prejudice to plant, animal, or human life and environment. Members may also exclude certain methods of treatment. These are specifically provided in the TRIPS agreement. Article 27.3a deals with them. They are diagnostic, therapeutic, surgical methods meant for the treatment of human and animals. Kindly note that these patents or exclusions are only with reference to methods patent, and they do not they are not related to products. So surgical products, diagnostic products, or therapeutic products may all be protected under patent law. These exclusions pertain to methods only in the sense that patenting such methods may be inherently seen as unethical, or sometimes countries may also argue that such exclusion is based on the fact that these methods may lack industrial application. However, there are countries which grant patents on methods of treatment. For example, the US does not make any distinction between methods and products and grants patents on all these kinds of inventions. And finally, what they have done is that they have limited the liability with respect to infringement by doctors. Ultimately, the end result is, even if these are provided under their patent law, the remedy is limited in nature. The US exclusion or remedies in case, limitation on remedies in case of methods treatment or methods of treatment arose due to a case called as the Palin case, and this law was subsequently amended, the patent law was amended to include such a principle that it should not be an infringement of the patent if there is a medical activity involved by physicians, etc. Other patent exclusions may relate to essentially biological processes, may exclude plants, animals directly. However, TRIPS agreement requires protection for microorganisms and non-biological or microbiological processes. The important question in this regard, especially in the context of biopharmaceuticals, is whether gene patents are included within the definition or excluded within the definition. In a recent Supreme Court decision in the United States involving ACLU versus Myriad Genetics, decided in 2013, the US Supreme Court has come to a conclusion that human genes are not patentable. The primary argument seems to be based on the ground that the information content in the gene prior to its isolation and post its isolation remains the same, and that is why, since the character of information does not change, they are rather products of nature. There is also currently a review going on with reference to article 27.3, and this is mentioned in article 27.3b, wherein WTO Secretariat has compiled a lot of information involving how patent protection is offered in case of plants, animals, and how effective sui generis system for plant is provided. It is important to note in this context that this kind of exercise is done because there was quite a lot of controversy at the time of signing of the TRIPS agreement, because based on this article 3.3 and the fact that microorganisms and some non-biological processes and microbiological processes have to be mandatorily protected, countries demanded that this particular implementation has to be reviewed. We will also look into a bit of disclosure. Disclosure is one of the important functions of the patent system. It is a quid pro quo in the sense that patent holder is given a limited market exclusivity based on the fact that he discloses his invention to the society. TRIPS agreement requires that this disclosure shall be in the best mode possible as on the date when the patent application is made, and also that the invention must be able to be performed by any ordinary person having reasonable skill in the art post the expiration of the patent. As mentioned earlier, TRIPS agreement went ahead in defining the rights of the patent holders in terms of defining the patent rights like making, using, selling, importation, offering for sale. However, in case of process patents, there is a reversal of burden of proof that is required by TRIPS agreement. This is very important because most pharmaceutical processes or any other type of processes are inherently tacit knowledge. So it will be very onerous on the part of the patent holder to prove that such a particular process has been actually infringed by the defendant. Hence, the burden is on the defendant to show that he has actually not infringed a process patent. In case of revocation, TRIPS does not mention any ground for revocation. So countries have ample flexibility to revoke patents on any ground that they want. However, most countries have gone ahead in revoking patents based on the ground that it does not qualify valid subject matter, that it does not qualify the disclosure requirement, it does not qualify the patentability requirements, novelty, utility, and inventive step. Also, India, for example, has gone ahead and said that patents may also be excluded on the grounds of public health or public interest. The term of protection provided under the TRIPS agreement is 20 years. This is provided by article 33, and it has been quite controversial whether 20 years is the actual time period that pharmaceutical companies may actually be able to recover its investment, but TRIPS does not settle this issue. TRIPS only provides a minimum kind of standard. It means members can also provide more extensive protection than that is provided in the TRIPS agreement. Certain limited exceptions have been provided under the TRIPS agreement. Article 30 talks about the 3-step test, that it must be limited, must not unreasonably prejudice or conflict with the normal exploitation of the patent, and must not unreasonably prejudice the legitimate interest of the right holder, taking into account interest of the third parties. These 3 steps came to be interpreted in a WTO dispute involving Canada Pharmaceuticals. In the Canada Pharmaceuticals case, the Canadian patent law had 2 exceptions. One is what is popularly called as the stockpiling exception, and second is what is called as the regulatory review exception. The stockpiling exception allowed generic companies to stockpile by making the particular drug prior to 6 months from the date of expiry of the patent, and the regulatory review exception allowed generic companies to actually infringe on the patent in cases where the generic companies were required to be in compliance for safety and regulatory procedures for getting a marketing approval. In case of the stockpiling exception, the WTO dispute settlement came to a conclusion that the stockpiling exception was not limited in nature, and that is why it was struck down as violation of Article 30 of the TRIPS agreement. It did not go further in determining the other 2 prongs of the 3-step test. In case of the regulatory review exception, the WTO dispute settlement came to a conclusion due to the nature of the requirement itself, in that the law made this exception because there was an external regulation which required certain compliance from generic companies. So wherever there was a compliance required, the patent law, having provided certain specific exclusion, may be considered as a valid exception. This is usually called as the regulatory review exception or the BOLAR exception. Article 31 provides other uses without authorization. While in case of Article 30, the uses may be free as such, in case of Article 31, the use must be compensated. However, Article 31, unlike Article 30, does not have any kind of a limitation as provided by the 3-step test. In Article 31, there are certain conditions that need to be followed. However, Article 31 does not mention the grounds on which such use without authorization may be granted. For example, a compulsory license, which is a form of an involuntary contract when enforced by the government, is granted. Such a compulsory license has to comply with certain conditions, but a compulsory license may be granted in any field and may also be granted on any ground. However, compensation is an important requirement, and TRIPS Article 31 requires that this compensation shall be in the form of an adequate remuneration. Article 31 also can be used to grant a compulsory license in case of violation of competition law. However, such practices which are declared as anti-competitive and for which a remedy is a compulsory license, such cases shall be determined by judicial courts. There is also certain procedural requirement and compliance that needs to be done in case of the TRIPS agreement, specifically where the patent holder has to be contacted and a voluntary license has to be sought from the patent holder prior to any third party approaching for a compulsory license, and only after failure to get the voluntary license for a sufficient reasonable period of time can any third party approach the government for a compulsory license. Furthermore, such a procedure may be avoided in case of certain emergencies like national emergency, circumstances of extreme emergency, or public non-commercial use. Article 31 also requires, specifically Article 31F, that whenever a compulsory license is granted, it shall be predominantly for the purpose of supply of domestic markets. Hence, there was a legal problem prior to the Doha Declaration on Public Health. Doha Declaration post the AIDS crisis in South Africa specifically said that WTO member countries have the freedom to determine the grounds for compulsory license and to determine the public health crisis. Paragraph 6 of the Doha Declaration also said that the WTO must find out an expeditious solution to overcome the problem raised by Article 31F, wherein a compulsory license may not be granted for the export purposes only. the problem encountered prior to the amendment of Article 31F was that WTO member countries could not export its pharmaceutical products by way of a compulsory license exclusively for those countries which had no manufacturing or insufficient manufacturing capacities. That seems to be resolved reasonably by virtue of August 2003 decision of the WTO and subsequent amendment to Article 31 by way of Article 31 bis. However, there are important conditions attached as to how this mechanism should function. One of the important conditions is that a request must be made by way of a notification at the TRIPS Council by the member country which is wanting to import. A subsequent notification has to be done by the exporting countries, and furthermore in both those jurisdictions, depending on the status of the patent law, a compulsory license has to be granted. And once the production starts and the export starts, there are certain requirements relating to how the product must be packed distinctly and how the product must be exported so that there is no diversion into domestic market or other foreign markets. So this primarily resolves the legal ambiguity created by Article 31F, wherein compulsory license were primarily meant for supply of or predominantly for the supply of domestic market only. With Article 31F amendment, WTO member countries based on the conditions prescribed can export, and compulsory license can be issued specifically for the purposes of export.